Hi, welcome to another video about how to plan for a better future for you and your family. My name is Edmund. I am an estate planning attorney, and today I'm going to show you the benefits of an estate plan and what happens if you don't have one. First, I want to show you what happens if you become disabled or pass away without an estate plan. Let's start with disability. A disability means that you're physically or mentally unable to take care of yourself and make your own medical decisions. This may happen if you're in a coma because of an accident or develop dementia or Alzheimer's. You might be thinking that your spouse and your children would be able to take care of you and manage your money if that happened. But even if they wanted to, they might not be allowed to. You see, the law sometimes acts as a double-edged sword. They're set up to protect your private information and prevent bad people from taking advantage of you. But that means no one but you, not even your spouse, can have access to your private information and act on your behalf unless you give them permission to do so. The law can prevent your own family from taking care of you or managing your money unless you go to court and ask the judge for permission to do so. This court proceeding is called a conservatorship. That's right, someone you love will need to spend time and money in court just to be able to take care of you when you're disabled. The good news is, later in this video, I'm going to show you what you can do today to make it easy for the ones you trust to take care of you and manage your money so that you can live comfortably without the expense and headache of a conservatorship. Okay, so now that we've covered what you and your family could potentially go through if you become disabled without an estate plan, let's talk about what would happen when something more serious happens, when you pass away. Before I dive into inheritances and who gets what, I want to focus on something more important. And that's making sure your loved ones will be able to take care of themselves financially if something happened to you tomorrow. Without proper planning, your spouse might not be able to continue paying the mortgage without your income, forcing him or her to sell the family home. Also, your children might not be able to afford college, which may or may not be a bad thing given the lack of jobs for new college graduates these days. And let's not forget the court proceeding called probate. If you own a few things at the time of death, such as money in your bank account and real estate, your family will have to spend a lot of time and money in probate court just to collect those assets. The entire probate process can take a year or even 2 years if your family fights over who should get what, and probate is very, very expensive. That's because your family will need to hire a probate attorney and the court will appoint a personal representative to handle the probate proceedings. The fees for the probate attorney and personal representative are set by law and based on a percentage of the value of your assets. For example, if your assets are worth $1 million, then the attorney and the personal representative will each be entitled to receive $23,000. That's a total of $46,000 plus other court fees that your family won't be able to get from you. And the attorney's fees will only increase if your family fights over your assets. Also, you won't be able to control who inherits your assets. If you don't have an estate plan, the probate judge will decide who gets what with the help of California law. And a lot of times, California law doesn't take into consideration your unique situation. For example, imagine you have a child who has abandoned you and can't stand to see your face. Well, that child will receive just as much as your other child who adores you and takes care of you. But what about your father who left you and your mom? He could receive as much as your mom who raised you all by herself. And what if you want to give some of your money to your boyfriend or your girlfriend or your best friend or that charity you support? Well, they'll get nothing under California law. As for your adult children who stand to inherit your money, they'll receive everything in one lump sum payment at the end of the probate proceedings, and they'll be free to spend every single cent of your money the day they receive it. That's not good, right? Most important, what's going to happen to your little ones? Your 6-year-old girl or your 10-year-old son? Who's going to raise your young kids if something happened to both you and your spouse at the same time? They might end up in foster care. Now that I've introduced you to the problems that you and your family will likely face if you become disabled or pass away, let's turn our focus to the solution. Let me show you exactly how an estate plan can protect your family. Your estate plan is a set of legal documents that will help you and your family prevent all the scenarios I mentioned earlier. These legal documents will contain your specific instructions on what you would like your family to do when you become disabled or when you pass away. First, your estate plan includes what's called a healthcare directive. In this document, you can appoint someone you trust to make your medical decisions and to take care of you if you become disabled. No one else but your medical agent can make those sensitive and important decisions for you. Also, your estate plan will include what's called a durable power of attorney. In this document, you can appoint someone you trust to manage your assets and finances so that you and your family will be taken care of financially during your disability. As you can see, the beauty of a healthcare directive and a durable power of attorney is that you can choose a person you trust to take care of you and your money during disability. And even better, that person will not need to spend the time and money in court to obtain a conservatorship to do that. This person can be your spouse, your child, your best friend, or a professional such as an attorney or CPA. And when you pass away, your spouse will have enough money to pay the bills and maintain the family home if you obtain adequate life insurance. Your estate plan will also include a legal document called a living trust. A trust is like a safe. You can put all your valuable possessions in there: your money, your stock portfolio, your house, your collectibles, or anything else you own. Inside your trust will also be a set of instructions of who you want your things to go to when you pass away. As long as you're alive and mentally stable, you hold the key to your trust, and you can take things in and out of your trust at any time as you wish. When you become disabled or when you pass away, the key to your trust will then be passed on to a person that you choose to manage your things. That person is called your trustee. Your trustee will follow the instructions that you left in your trust and distribute the things inside your trust as you wish. For example, you may want to give most of your money and your house to your wife, your stock portfolio to your children, your collectibles to your best friend, and some of your money to your charity and even your pet. The best part about a trust is that you get to control where your things go, and your loved ones will receive them without going to probate court, saving everyone a lot of time and money. Also, if you have doubts about your children's ability to use your money wisely, you can dictate under what circumstances your children can use your money. For example, you can say that your son can take out money from your trust only to pay for his education and living expenses. With a trust, you can control how your money is spent even after you've left this world by leaving these specific instructions for your family to follow. So, in a nutshell, that's what a trust does. Your estate plan will also have a will that works together with your trust. This will is called a pour-over will, which covers any personal belongings that have not been transferred to your trust. One of the most important components of a will is that you can designate a guardian to raise your kids if something happened to both you and your spouse. The last thing you want is to have your kids stuck in foster care because you didn't plan ahead. As you can see, your estate plan provides clarity, certainty, and protection for your family. Okay, let's recap each component of your estate plan. Number 1. A healthcare directive allows someone you choose to make medical decisions for you if you become mentally disabled. If you don't have one, a judge will decide who can take care of you. Number 2. A durable power of attorney allows someone you choose to manage your money for you if you become mentally disabled. If you don't have one, a judge will pick one for you, and sometimes judges can be deceived by those who just want to have access to your money. Number 3. Adequate life insurance ensures that your spouse and children will be taken care of financially if they had to live without your income. Number 4. A living trust gives you power to choose who receives your most valuable possessions when you pass away. It also helps you manage how your loved ones can use the money you leave them, while avoiding the expensive and exhausting process of probate court. And number 5. A pour-over will covers any personal belongings that have not been transferred to your trust, and it designates a guardian to take care of your young children. When you complete your estate plan, both you and your spouse will feel relieved knowing that you have a plan in place if one of you becomes disabled or passes away, and you'll have a living trust to provide for your children if something happens to the both of you. People say that estate planning is complicated, takes a lot of time, and is only for the ultra-high net worth. As I showed you in this video, estate planning solves problems that the average family faces, and it's not only for the ultra-high net worth. In most cases, estate planning is even more important for the average family because dealing with death and disability without an estate plan is substantially more expensive than having one. And it's not complicated if you have the right person to guide you along. Okay, you should now be familiar with the basics of estate planning. If you want to learn more, I invite you to check out my blogs and other videos on topics that will affect you and your family. I promise you that the more you know, the more prepared you'll be to protect your family's future. And please, don't procrastinate. That's one of the biggest reasons why more than 60% of Americans don't have an estate plan, and why the probate industry is booming. Plan today to prevent the unnecessary costs and stress that your family will have to deal with if something happens to you tomorrow. Okay, that's all I have for today. I'll see you next time.